Hi there, my name is Alistair Dougal and I'm the Senior Associate at Parish Patients Immigration Lawyers. Now today I'm going to be talking to you about visa cancellations. Now we all know that the department has the ability to grant a visa, but they also have the ability to cancel a visa under certain circumstances. Now a visa can be cancelled for numerous reasons. It can be cancelled if the holder does not comply with the conditions attached to that visa. It can be cancelled should the individual be convicted or in some instances even merely charged with a criminal offence, which causes the department to have concerns that they may pose a risk to an individual or the community at large. And the department also has the power to cancel a visa if the individual has provided incorrect, false information or false documents in an application for that visa, or even a visa application that was made for a visa they held before the current visa they held. So the department's power in some instances is actually able to be extended so that if someone has held a visa many years ago, which they provided a false document for, even if they've subsequently lodged a further visa application and that visa has been granted, and even if all the information in that current visa is true and correct, the department can actually cancel the current visa based upon the fact that a previous visa that was applied for was obtained through fraudulent means. This is what we can call retrospective cancellation. Now, a cancellation of a visa does not happen automatically. The department will write to an individual and normally give them 7 days to respond to the concerns that they have. And that also the department allows the person to request a further 7 days in addition to that initial 7-day period. But under statute, that really is the limit that the department can provide. Now, of course, there are other situations where the department may give more time on visa cancellations, but for general cancellations, it is generally no more than 14 days from the day of notification that you are allowed to have to respond. Now, when cancelling a visa, the department will consider multiple elements of your case, and under law they have to assess what we call mandatory considerations. Now, the department will assess the mandatory considerations in a situation where a breach of the visa condition has occurred, or obviously if the person does admit that they have provided false information in a previous application. At that time, the department will say, well, the non-compliance has occurred, so we will now look at whether or not your circumstances have anything in them that would cause us not to proceed with cancellation. The department will weigh up the mandatory considerations. They will weigh it up against the non-compliance and the extent of non-compliance, and then they will make a decision. Now, if they decide not to cancel the visa, then they will just simply notify the visa has not been cancelled. But if any further information comes to light in the future, then cancellation proceedings may, of course, be initiated again. The department may also say that there are grounds for the cancellation, but given the fact that we've looked at all the situations in your case, we've decided that we're not going to cancel, we're going to give you some leniency. However, in many situations, the department will proceed to cancel the visa, and the person will become an unlawful non-citizen in Australia. In this situation, the person must lodge an appeal to the Administrative Appeals Tribunal within a very limited period of time from the date that they are notified of cancellation. Once the appeal has been lodged, they must then make an application to legalise themselves with a bridging visa E. Otherwise, they will continue to remain unlawful and they will be liable to be detained and taken to immigration detention until they either make an application for review or the department arranges for their removal from Australia, whether that be voluntarily or non-voluntarily. Now, in certain situations which involves serious character issues, the department will cancel automatically and then ask for a reason as to why the visa should be reinstated. These are all very serious situations, and you should automatically seek legal assistance the minute you are notified the department has concerns and they are seeking to cancel your visa, or they are at least considering cancelling your visa. At Parish Patients, we have a very long history of complex matters. We have an extensive history in cancellation matters, And our accredited specialist, Michael Jones, who's our legal practice manager, has a very long history dealing with and specialising in cancellation matters, and he's passed on that knowledge to all the other staff at Parish Patients. So we're all very well equipped to assist you. We know what needs to be done to give you the maximum chance to be successful, to not have your visa cancelled, or to prepare you for a review application to review a decision to cancel your visa. So if you do receive a notice of intention to consider cancellation, we advise that you should contact us immediately so that we can assist you to have the best chance of success. Thank you for listening, and we wish you all the best.